afternoon, everybody. A very warm welcome to Compass Chambers Spring webinar. I'm glad to see so many of you have not succumbed to the allure of an hour's shopping at Primark and have decided to join us instead. Unfortunately, as you know, our usual programme of conferences have been disrupted, hopefully not for much longer, but we thought providing a webinar at least gives us an opportunity to update you on some developments in our core areas and a good opportunity to maintain contact and have some discussion. Now, according to our advertised programme, our first speakers were scheduled to be Steve Love and Grant Markey. Unfortunately, due to personal circumstances, they're not able to speak today, but we shall include their talk in the future. Shortly we'll be moving straight on to start with Kay Springham QC and Bruce Langlands discussion about the limits of limitation in sexual abuse cases. But it might be that we do finish a little earlier than the anticipated 1:30, so you might still have time for a dash out to the shops. We would very much like this to be an interactive event. I'm sure you would all agree that that makes it much more interesting for everyone, particularly at the moment when we've had so little opportunity for interaction and discussion. It'd be great to hear thoughts, observations, or questions that you have. So we would really like to encourage you to do that. In terms of how you do it, there is a chat function. You'll see that at the bottom of your screen, hopefully. If you click on the tab at the bottom, and then if you type whatever question or observation you have, we will use that as the basis to form a question and answer session at the end. Now, I'd like to say just a little about our charity. As you know, we don't ask any fee for this seminar, but we would like to ask you to consider making a donation to our nominated charity this year, which is the Beatson Cancer Charity. As with so many charities, this has been a very challenging year for them, but they do rely on donations to support patients and families. And many of the services have been cut during the pandemic, but the Beatson has been able to adapt and provide things like digital one-to-ones. They've implanted a befriending service, stress management, and drop and go are just a few of the initiatives that they've managed to put in place. Also, research and technology is obviously a huge part of what they do. And with facing the potential for a backlog of treatments and diagnosis, this is a huge focus for them. Another thing is that their therapists are getting to provide hair and wig services again, and some other complementary therapies, and even £25 would fund an hour of that. If you'd like to find more information about the charity, there is a website at beatsoncancercharity.org. And if you'd just like to make a donation, you'll find a Just Giving page on the Compass Chambers website. So it'd be lovely to see the figures for the charity getting a bit of a boost after today. If I can turn now then to our first two speakers. I'm very pleased that we have Kay Springham QC and Bruce Langlands to discuss the limits of limitation in the context of child abuse legislation. I'm sure Kay Springham QC is very well known to you with a flourishing practice in personal injury and clinical negligence work, and also a very strong leader in judicial review and human rights work. In addition to that, Kay does a lot of work in relation to disciplinary matters and is a board member of the SLCC. Kay took Silka in 2016, and we are particularly lucky today because Kay is actually on her holidays. What's a holiday, I hear you all ask, but Kay, lucky stick that she is, she has one, so thank you very much for that, Kay. And Kay is joined by Bruce Langlands, who called in 2019 having worked before as a solicitor and as a successful solicitor advocate with Digby Brown. Since then, as I'm sure many of you know, Bruce, he's built up a busy practice in personal injury litigation, working in all areas for both sides of the fence. So thank you both in advance, Kay and Bruce, and if I can now just hand over to you.
Thank you very much, Amber. And thanks everyone for coming to watch today. So what Bruce and I are hoping to talk about is some of the case law that's arisen under the changes that have been made to limitation in childhood abuse cases. As many of you will know, there was an act in 2017, the Limitation Childhood Abuse Scotland Act, which removed the limitation period for actions of damages in respect of personal injury resulting from childhood abuse. And that means that there is now no limitation period for those kinds of actions. What we're focusing in on today is the limits to the removal of the limitation period, and in particular we're looking at section 17D of the 2017 Act, or the Prescription and Limitation Scotland Act as amended, which sets out circumstances in which an action may not proceed. So since it's maybe not at the tip of your tongue and the forefront of your mind, we, I think, can share a screen which will show you section 17D. And if my glamorous assistant can do that.
I'll take that. I shall do my best.
Well, you managed it earlier in our practice run, so hopefully we'll manage it again.
There we go. It should hopefully work.
Yes, I can certainly see it, and hopefully others can see it too. So we've just set out on the screen for you section 17D, and in effect it says if you've got an action which is brought by virtue of section 17A1 and either of subsections 2 or 3 apply, then the court may not allow an action to proceed. And the relevance of all of this is because the change to limitation doesn't just apply in relation to incidents which occur after the 2017 Act. They also apply to incidents which have occurred before the 2017 Act, and even in relation to cases which have been litigated in certain circumstances. So you'll see from looking at the section that there are 2 specific provisions where the court may not allow an action to proceed. And the first one, subsection 2, is where the defender satisfies court at a place. And then 3, read short, is A, if the defender satisfies the court that they would be substantially prejudiced were the action to proceed, and then having regard to the pursuer's interest in the action proceeding, the court is satisfied that the prejudice is such that the action should not proceed. So there are not very many published decisions so far in relation to section 17D, but there are 2 published decisions that we can talk about. One is under 17D2, so that's the fair hearing one, and the other one is under 17D3, which is the substantial prejudice one. And what we're going to do is we will, I'm going to say a little bit about the section 17D2 case, just to introduce it, and then we're going to have a discussion, Bruce and I, as to what we think you can take from it, whether the court got it right and such like, and what we might be able to say for the future. And then Bruce is going to say a little bit about the 17D3 case, and we're going to do likewise. And then if there are questions for us, I think the plan is that we're going to deal with those at the end of our talk. So if I can just introduce the 17D2 case, which as some of you may know, is a sheriff court case. It's LM against DG's executor, which is reported at 2021 Sheriff Appeal Court Civil 3. And this was a case taken on appeal from the decision of Sheriff Lorna Drummond. Just to give you a little bit about the background, in case you're not familiar with it or just need a refresh, the circumstances are that there was a claim of sexual abuse which had been carried out allegedly by the deceased when the pursuer was a child in 1981, and that extended over a period of about 5 years. The DG had appeared on petition charged with sexual offences against LM, but died shortly afterwards, I think a matter of a week or two after he had appeared on petition. The defender pled section 17D2, in other words, saying, I can't get a fair hearing, relying essentially on the fact that the person against whom the claim was made was dead, and therefore it wasn't possible for them to advance a defence. Initially, Sheriff Drummond said that it wasn't really possible to tell in advance if a fair hearing could be had or not, and allowed a proof at large. That was then appealed by the defender. The Sheriff Appeal Court disagreed, and they allowed a preliminary proof, saying that a decision on the fairness of a hearing could not be made in the abstract, and the evidence required to be heard at the preliminary proof, that it wasn't right to send it off to a proof at large. And I understand from speaking to the Defenders Council that as yet there has not been a preliminary proof. So what do we learn from this case? And do we think that the Sheriff Appeal Court got it right, or that Sheriff Drummond got it right? What do you think, Bruce?
I think the answer to that question really depends on whether you're pursuing or defending these cases. And I say that from someone that only has pursued these cases so far, but a reasonable number of them. I think the difficulty for pursuers with the decision is that if these cases are ultimately going to go to a preliminary proof, and if they don't settle, the vast majority of them will, based on this decision, is it is ultimately going to prolong the cases, assuming that you clear the hurdle and get through the preliminary proof. And it may well be that many people, including the people that have been or survivors of this, are going to have to come back potentially to repeat their evidence, not just the pursuers, but any witnesses they've got as well. So I think from a pursuer's point of view, it's not ideal. From a defender's point of view, I can see the attraction in the decision because it may well resolve it at an earlier stage. But the difficulty, and I've always maintained this for defenders, is if these cases run to proof before answer, so you have the proof before we have the legal argument on Section 17D defences, if that argument on the Section 17D defence was to fail for the defender, they can't rely on that, so they're going to have to put their best foot forward and run the case properly. But it may well be that in trying to run the case properly, lest the 17D defence fails, they actually undermine their Section 17D defence. And it may become harder for defenders at a proof before answer to argue that the case should succeed or shouldn't succeed because of the 17D defence. So whether the court's got it right or not, I think depends on which side of the case you're on. That's my view on it, Kay.
But one of the things that you mentioned was that if there is a preliminary proof procedure, then it's likely to prolong the case.
Yeah.
Might it be argued that there has already been a delay in bringing the case in the first place, and therefore why should the pursuer get the benefit of saying, well, I don't want my case to be delayed anymore?
It's an interesting question. I think it depends on what side of the table you're on, I suppose. But from a pursuer's point of view, and even from the defender's point of view, I mean, anybody that's, once a litigation's going, people want it resolved sooner than later. If there's to be a preliminary proof fixed at the moment, they're being fixed around about the same time that your proof at large would be fixed on a normal court timetable. So you have to have that, and then ultimately it'll be whenever the court can then fix in the final proof. So yeah, I can see the argument. Well, why should you get to argue about there being a delay when it's taken you multiple years to proceed with the case? But once it's running, is it not in everybody's interest that we get to the end as quickly as possible?
I suppose the other thing that a defender might say is that, well, the onus is on the defender here under this section 17D2. It's the defender that has to satisfy the court. Yep. So that's actually quite a high hurdle for the defender to reach. And if the court looks at what evidence is available, might be available, etc., and isn't really satisfied that it's just not possible for a fair hearing to take place, then they will send it to a hearing, which isn't to say that the defender might not, at the ultimate proof, still be able to argue.
Absolutely.
Actually, I'm not getting a fair hearing here, under common law or under Article 6 of the Convention.
Yep. So,
yeah, I mean, I think it, it's like it has to be a compromise, doesn't it? And I think when you look back at the debates that went on in Parliament and the submissions that were made by various interested parties, that they had to find some sort of balance to strike between, defenders who are potentially being faced with incredibly stale claims, which may have a significant value.
Yep.
And people who have suffered wrongs. And so there's trying to sort of find a balance there. I suppose the fact, as I say, that the onus is on the defender gives the pursuer an advantage, because it's really up to the defender to prove they can't get that fair hearing.
Yeah, and I don't disagree with that at all, that the onus is on the defender, but it's the point at which that defence is taken that's of interest. And that's what's interesting from this decision. I mean, in a lot of cases like this, you may expect these sorts of decisions as to whether there's a fair hearing can be had to be made at a debate rather than a preliminary proof, for example. But of course, the Sheriff Appeal Court, and in fact, agreeing with the Sheriff, said that actually you can't determine the matter until we've heard the evidence. And I think that's an interesting point as well, because they're obviously not just looking at a straightforward view of documentary evidence. There obviously must be some evidence that they're expecting to be given in an oral format, or by affidavit, might be another way. But if it's to be done by affidavit, why not deal with it at a debate? Why are we going off to preliminary proof? Because I suspect the debate could be dealt with faster. But it's interesting that they're obviously looking for some sort of evidence, or expecting to see evidence to be heard in court, and they say as much in the decision. So yeah, it's, as I said, it really depends what side of the table you're on, whether you like this decision or not. But from my point of view, I don't think it's a groundbreaking decision by any stretch. And actually, are we seeing any answers to the question of when are these cases going to be allowed to proceed and when are they not? I don't think we have an answer to that, or we don't have an answer to that yet either from either of the two cases, really. So yeah, I mean, we're limited because we've only got these two decisions, but I just don't think that they're as good as I would like them to be. For, these are the first two cases we've had on this law. It'd be better to have seen a bit more from them, I think. I don't know what you felt about that, but I felt they were lacking in some respect.
I mean, certainly looking at the decision from the Sheriff Appeal Court, it's pretty short actually on the reasoning. It just kind of says, isn't it obvious that this has to be dealt with as a preliminary matter, without really giving much more than that. Sheriff Drummond, to be fair to her, did give quite a lot of thought to it and looked at how matters are dealt with in the criminal sphere, and whether she could take anything from those decisions. So I'm not sure that defenders will be able to simply say to pursuers, agents, well, the Sheriff Appeal Court have said it's got to be done as by way of a preliminary proof. For example, if you're in the Court of Session, it's persuasive, but it's not binding on the Court of Session. And therefore, you'd be entitled to say, well, actually, they did get it wrong.
Yeah. No,
Here's why.
I've certainly tried that argument in certainly one I can remember, if not two cases that have been into the Court of Session on the back of this decision, which the defenders have latched onto the Sheriff Appeal Court decision. And in fact, whether the Court of Session is following that decision or not, certainly those cases have also been sent to preliminary proof. So it appears at the moment that that's the way these are going to be dealt with. And I'm not saying there's a blanket view on that. There may well be cases where it's just so obvious that it doesn't need to go to preliminary proof and it can carry on, or in fact be dismissed. But I think that's less likely. But I just don't think there's much we can take from this at this early stage of the legislation. There's no. I think what people are really hoping for, I suspect, is guidance on what are we doing in what cases and when are these going to proceed, when are they not, and we just don't have that yet.
Well, it may be that until we have a body of case law that we're not really going to have that. But I wonder, Bruce, could we maybe move on to the other case that we're going to talk about, which you're going to talk about, because sadly I lost in this case, although we are reclaiming. So hope is not lost, but you can tell me all about it and where I got it wrong.
I'll tell you about the case. I'll not tell you where you got it wrong. So the case is A against XY Limited in the Outer House. Decision was published, I think, in February. And that case, again, is a historic case, but it's, I say it's from 1987, so 35 years ago, roughly. A junior pupil at a school, age 13, was taken on what I understand to be an all-female camping trip with a young male teacher, who, during the course of the camping trip, raped the 13-year-old in a tent. And the 13-year-old is now, or has now raised proceedings against the school, as I understand it, seeking damages for what happened. And this case, unlike LM against DG's executor, is concerned with the Section 17D3 defence. So there's no argument about a fair hearing in this case. And I understand that that's because the perpetrator, in fact, is still alive, albeit doesn't appear to have, at the moment, anything to do with the proceedings. As I said, they're against the school. So it may be, you can tell me if I'm wrong, it may be felt that there couldn't be a fair hearing argument where the perpetrator remains alive. But nonetheless, the court was interested in the substantial prejudice argument. There's a couple of interesting things to take from this decision, I think, from Lord Woolman, which is that, first of all, in terms of substantial prejudice, we can't really look back at the cases that predated the 2017 Act when cases were dismissed due to prejudice, because the test was different to what's set out in the legislation. So the previous sort of iteration of the test was whether the defender was significantly prejudiced or suffered significant prejudice. And that was used in B against Murray, which was leading House of Lords case on this, which came in before the 2017 Act. I think it was around about the early 2000s. But the legislation is talking about substantially prejudiced. So the court said that we can't really look back with any degree of helpfulness at the previous decisions. But in terms of the substantial prejudice test, it's a couple of observations, I suppose. The first is that the defender has to satisfy the court that they would be substantially prejudiced, and that the court then has to have regard to the pursuer's interest in the action proceeding and strike a balancing act. And it's been a bit unclear until now. It may still be unclear, I suppose, but a bit less clear up until now as to whether the second part of the test, so 17D3B, which is the pursuer's interest, who carries the burden in relation to that? There has been a school of thought that it's actually up to the pursuer to prove in the normal course of events on balanced probabilities that her or his interest in the action proceeding outweighs the defender's. But Lord Woolman appears to be saying that's actually an issue for the court at large to deal with, and it's a balancing exercise for the court, and therefore there isn't as such a burden of proof that the pursuer requires to discharge. So that's a helpful point. But ultimately, the decision came down to this. Lord Roman said that the defender is in fact substantially prejudiced because up until the action was raised, the defender was entitled to assume that there would be no liability for this. Now, I wasn't clear, Kay, maybe you can tell me in a moment whether that's because simply the legislation, the time bar changed with the 2017 Act, or whether it was on the back of the Lister-Hesley Hall decision. I wasn't quite sure from Lord Wormland whether he was saying it was one or the other or both that caused the substantial prejudice for the defender, but ultimately the defender is substantially prejudiced because they've been entitled to assume for so long that there wasn't going to be any liability arising from this, and may now require to pay a considerable sum of money. I think the sum sued for was £1.5 million. Notwithstanding that, though, the court has determined that the pursuer's interests do outweigh the defender's substantial prejudice, and that the action should be allowed to proceed. And the basis for that was that ultimately the pursuer has been the victim of a detestable crime at the more severe end of the scale. And on that basis, her interests outweigh the defender's. So again, there's no hard and fast rule that I see coming from this. Kay's obviously said that the case is being reclaimed. But Kay, maybe just on the first point I was talking about there, what was your understanding of the basis for why the defender is substantially prejudiced?
Well, my understanding was that it was effectively because of the change of the law in Lister, combined with the removal of the limitation period. So, had the pursuer raised proceedings within 3 years of her turning 18, then there would have been no liability on the part of the school, because the law on vicarious liability was different then. So when Lister came along, obviously that changed the law in relation to vicarious liability, which is why the pursuer is able to make the claim now, combined with the 2017 Act. So it was really, as I understand it, a combination of the two of those as to why the Lord Ordinary thought that defenders were substantially prejudiced.
Yeah. So you
does that help?
Yeah, absolutely. That was my understanding from reading. Sorry, my understanding from reading it was that it could be a combination. It just wasn't totally clear. Obviously, it's being reclaimed, so there's no doubt a discussion to be had at a future point as to whether or not either the defender is substantially prejudiced or whether the pursuer's interests outweigh that. I'm not sure at the moment that, again, there's anything particularly decisive that can be taken from this that's really of any use. Again, it's quite concerning that on the first judgment from the Court of Session on the new law spans 13 pages, of which the discussion around the law is only about 3 or 4 paragraphs. I don't know what your views on that. Presumably it's not ideal from an appeal point of view, that there's so little reasoning given.
Well, yeah, and I think it is disappointing, and I'm sure Jeff Clark, who was my opponent, Jeff, obviously another member of Compass, he although he's won the debate, it is disappointing given the amount of time and effort that was put in by both sides to looking at the law and what we thought the law was, and gut, hill and down dale, that we've got really very sparse reasoning. But I think to talk also a little bit about what that means at the point at which you get to the balancing exercise. What the legislation says is that you have to take into account the pursuer's interest in the action proceeding, but we don't really know what that actually means. I mean, it's pretty much a given, you would think, in any case involving childhood abuse, that the pursuer would have an interest in the action proceeding. But how do you decide whether that interest outweighs the substantial prejudice that has already been found in relation to the defender. And one thing that I would say is that it can't just be about the extent of the value of the claim. It can't just be about, oh, this is a claim that's potentially worth 1.5 million. Therefore, the pursuer must have an interest in it proceeding, because there might well be claimants who have suffered awful abuse, but they don't have a claim to that extent because they were never in the position that the pursuer says she would have been in this case, which is she'd have become a vet, ears been destroyed, etc. There might well be people who had horrific abuse, but who never were going to be, a successful professional person, and therefore may not have a sort of large loss of earnings claim. But that doesn't mean that they have any less of an interest in the case proceeding. So I don't know the answer. We tried to explore the options, but I don't think that Lord Wilman has really given us an awful lot of answers about that.
No. The other observation I was going to make, maybe just before we sort of come to wrap up.
Yeah, I think we better wrap it up. We're kind of running out of time, I think.
Yeah, is the legislation obviously says that the subsection applies to the defender satisfies the court that as a result of the limitation change, try that again. The defender satisfies the court as a result of the claim now being brought, that the defender would be substantially prejudiced for the action to proceed. So the legislation is setting out a need for the defender to satisfy the court that it's substantially prejudiced. But the decision from Lord Wilman effectively says that if we're right in our assumption that it's because of Lister and because of the 2017 Act that the defender is substantially prejudiced, well, from my point of view, and you may disagree, but is a defender not going to be substantially prejudiced in every case then? In which case, where's the need for the defender to satisfy the court that it's going to be substantially prejudiced? And is what Lord Wilman's decided as the basis for substantial prejudice in this case really what the legislation was driving at? It doesn't strike me the defender's really going to have to do anything in any case to satisfy the court if that's the basis of the decision.
Well, Lister isn't going to be beneficial to every defender. It wouldn't be beneficial to the alleged perpetrator in this case.
No, that might be right, but the change in the 2017 Act is obviously going to be of interest in just about every case. Well, in every case where we're considering that defence is because of the legislation change. In which case, on the basis of the reasoning in this decision, well, every defender is going to satisfy the court substantially prejudiced. In which case, we then get into the difficulties with the balancing exercise you were just talking about.
Well, as I say, not every defender will be able to rely on Lister, but it was a matter that was considered as part of submissions by various parties to the Justice Committee. And in effect, they said, well, that's a matter that the court's going to have to rule on. So it was in contemplation that the change of law in Lister might well be something that could cause substantial prejudice to defenders. Anyway, we've gone over our time. So, well, we're going to call it a halt there. Thank you for listening, folks. And I think there's a couple of questions come up, and if we've got time at the end, we'll do our best to answer them. Thank you very much.
Thanks very much, both of you. I thought that was excellent, and it was a fantastic format to have the discussion between the two of you, which was great. And yeah, we do already have a question. If anyone else can post anything, then we'll pick that up at the end. If I can now move to our next speakers, we have Susan Duff and Adam Black, who will be talking about piercing the corporate veil in regulatory cases. Susan called at the bar at 2003, and I'm sure most of you will know of our very specialist expertise in the field of regulatory prosecution and enforcement proceedings, and our extensive experience in fatal accident inquiries. Susan came from a distinguished career within Crown Office, but hasn't looked back since calling at the bar, and now has a very vibrant practice. And Adam Black joined us at the bar last year, working as a solicitor for 3 years before then. He has a wide range of work in all areas of personal injury, with an interest in mental health law in particular. But more recently, he's developing his regulatory crime practice. So if I can turn over to you now, Susan and Adam, thank you.
Thank you.
Thanks, Amber. Adam and I have decided to take a different format from Kay and Bruce. We want to just give you a whistle-stop tour around a very niche area of regulatory crime. So for those of you who practice in the field of regulatory crime, you know that the law in this field is highly structured. And for ease of reference, we are going to focus on health and safety law. It's the area most commonly encountered in enforcement proceedings and prosecutions in Scotland. And most commonly, you will be dealing with corporate clients who are accused of health and safety breaches. But when they are accused, and once you have set out how prosecution works in Scotland, one of the first questions you will be asked is, how much is this going to cost? And we'll come back to look at that later. But in order to consider that question, you have to know exactly what you are dealing with. What is the nature of the client? If the client is a single limited company, your advice is straightforward. If the client is part of a group of companies, you will have to consider how that group and those companies are structured. Why, you might ask, does that matter? Well, the health and safety offences, corporate manslaughter and food safety and hygiene offences definitive guideline came into force in England and Wales on the 1st of February of 2016. On the 12th of May 2016, Scottish Power Generation Limited pleaded guilty to a contravention of Section 2 of the 1974 Act at Dunfermline Sheriff Court. The plea was causative of severe injury, permanent disfigurement and impairment. And on the 31st of May 2016, the Sheriff fined the company 1.75 million, which was modified from 2.5 million to take account of the early plea. On the 3rd of November 2016, Scottish Power's appeal against sentence was heard by the appeal court. The appeal court refused the appeal, and in its decision, the court said, the Sheriff, in selecting the penalty, has used the matrix in the 2016 guidelines. He said in his report to the appeal court that he determined that he should have regard to the new guidelines. There was no reason for levels of fine to be different north and south of the border. He also said that he looked at the level of fine through the prism of the pre-guideline Scottish decisions. And apart from the level, which was higher in the guideline, he considered that he took into account the factors which had been considered relevant in the Scottish cases. The appeal court went on to say, the court has, on several occasions, encouraged sentencers to have regard to guidelines from south of the border in appropriate cases, notably, but not exclusively, those involving UK statutory offences. Quoting earlier cases, the court went on to say this: while the court has encouraged sentencing judges to have regard to the English guideline in death by dangerous driving cases, it has not said that it should be interpreted and applied in a mechanistic way. In order to ensure a degree of consistency in this jurisdiction, albeit paying due regard to local circumstances, it may be equally important to have regard to existing precedent. The court continued, quoting from other earlier cases, guidelines from the Sentencing Council will often provide a useful cross-check, especially where the offences are regulated by a UK statute. So what happens in practice? Since Scottish Power, the courts in Scotland have routinely used the matrix in the sentencing guidelines to reach a sentence that the Sheriff considers to be just, having regard to all the circumstances. The courts routinely receive a submission on sentencing from the Crown, which directs the court's attention to the sentencing guidelines and to Scottish Power and the earlier Scottish cases. We consider that it is unlikely that a court imposing a sentence in Scotland for a health and safety breach would not refer to the guidelines. So you're all asking, what has this got to do with piercing the corporate veil? Step 2 of the guidelines is starting point and category range. It states the following: having determined the offence category, the court should identify the relevant table for the offender on the following pages. There are tables for different sized organisations. At step 2, the court is required to focus on the organisation's annual turnover or equivalent to reach a starting point for a fine. The court should then consider further adjustment within the category range for aggravating and mitigating features. At step 3, the court may be required to refer to the other financial factors listed below to ensure that the proposed fine is proportionate. Step 3 of the guideline states in bold, the fine must be sufficiently substantial to have a real economic impact, which will bring home to both management and shareholders the need to comply with health and safety legislation. It also states the court should examine the financial circumstances of the offender in the round to assess the economic realities of the organisation and the most efficacious way of giving effect to the purposes of sentencing. In terms of the guidelines, the offender is expected to provide comprehensive accounts for the last 3 years to enable the court to make an accurate assessment of its financial status. It states, normally, only information relating to the organisation before the court will be relevant unless, exceptionally, it can be demonstrated to the court that the resources of a linked organisation are available and can properly be taken into account. So that is what this has got to do with piercing the corporate veil. In sentencing, can the court look behind the distinct legal persona of a limited company and go on to consider the financial position of the group in assessing the appropriate level of penalty? And this is generally referred to as piercing the corporate veil or lifting the corporate veil of linked companies. And this issue has been considered in a number of English cases. And I will now hand you over to Adam, who is going to take you through the most relevant English decisions. Adam, over to you.
Thanks very much, Susan. For all of our attendees, I should say that a full citation for each of the cases I'll be referring to will be available in a handout which should be circulated after the event. But for ease of reference, I'm going to use shorthand names. The first case we're going to consider is the decision of the Court of Appeal in the Health and Safety Executive and Tata Steel UK Limited. Now, Tata Steel UK is a wholly owned subsidiary within the Tata Steel Europe Limited Group. Its ultimate parent company is Tata Steel Limited. In the UK company's 2015 report and accounts, it is stated that the directors had a reasonable expectation that the company had adequate resources, including the support of TSL, its parent company, to continue in operational existence for the foreseeable future. The company had a turnover of £4.17 billion in the year ending March 2015, but recorded a loss after taxation of £851 million. Now, during the accounting year, it had restructuring and impairment costs of £314 million. The Court of Appeal said that it accepted that the financial circumstances of an offender are to be taken account as the sentencing guidelines recognises under Step 3, and that a small profit margin relative to turnover or a loss-making business may warrant downwards adjustment in any fine. But the court said that when examining the financial circumstances of the offender, those circumstances have to be examined in the round to assess the economic realities of the organisation. In that regard, when determining annual turnover for the purposes of Step 2, the guideline will provide that normally only information relating to the organisation before the court will be relevant, unless exceptionally it can be demonstrated that the resources of a linked organisation are available and can properly be taken into account. Now, the court said in this case it had in mind the separate corporate personalities of Tata Steel UK and TSL, the parent, in their approach to the matter. However, when determining whether this was an exceptional case, the court looked at Tata Steel UK's accounts, which included the following paragraph under the heading Going Concern. The account said, after making inquiries, the directors have a reasonable expectation that the company has adequate resources, including the support of its ultimate parent, TSL, to continue in operational existence for the foreseeable future. Accordingly, they continue to adopt the going concern basis in preparing their financial statements. The court said that on that footing, it seemed to the court that this was one of those exceptional cases within step 2, where the resources of TSL, as well as those of Tata UK, could properly be taken into account. Indeed, the court said, as the support of TSL was plainly of the first importance in ensuring that Tata UK could continue to prepare its accounts on a going concern basis, it would seem to the court that wrong not to take the position of TSL into account, because the removal of TSL's resources would have produced a misleading and unrealistic picture of Tata UK's financial circumstances. The court said that what it was doing was recognising the economic reality of the situation. Now, in another case, this one's Faltac Europe Limited against the Health and Safety Executive. Faltac was a wholly owned subsidiary of a Japanese holding company. It was a company which was incorporated in 1989 and traded since then as a manufacturer of car parts for Nissan's European plants. In the years leading up to 2019, it had a turnover of between 33 and 39 million pounds per year. It reported a profit in 2015, but ran at a loss in the subsequent years, subsisting largely on loans and share capital issued by its holding company. Now, the holding company, however, had a worldwide turnover of between 550 and 600 million pounds per year, and an annual accounting profit of between 10 and 20 million pounds per year in each of those 3 years. Now, in that case, it was agreed that Faltac was a medium-sized organisation in terms of step 2, but the court noted that at step 3 of the guidelines for sentencing contemplate the decision maker stepping back and considering the proportionality of any fine imposed. The court said that here the judge acknowledged that Faltac was trading at a loss, but that was not the position of the holding company. And having regard to the statement in Faltac's 2015, 16, 17 accounts, going to it enjoying the full support of its holding company and its position as a going concern, the sentencing judge concluded that some limited regard was to be had to the holding company. The appeal court considered the position of the holding company and said, generally, there is no dispute as to the principle of separate corporate personality. Criminal liability is personal, and a fine should not be imposed on the basis that it will or might be paid by a third party. The question instead then is whether, as the guidelines expressly provide, this was an exceptional case where the resources of the linked organisation are available and can properly be taken into account. In that regard, the court should consider the financial circumstances of the offender in the round in assessing the economic realities of the organisation. As we saw, the decision in this point in Tata Steel was based on the economic realities test. That was an exceptional case because it was clear that the support of the parent was of the first importance in ensuring that the company could continue to prepare its accounts on a going concern basis. Now, whether the economic realities test is satisfied will depend on a fact-specific inquiry in the individual case. There's no catch-all answer, and in any event, the question has to be approached with a degree of caution. Now, ordinarily, it's only the resources of the offender which are to be taken into account, and the fact that companies are members of the same group or have subsidiary parent relationships will not of itself satisfy the test. It's only exceptional cases where the resources of the linked organisation fall to be considered. Now, the court concluded in Faltac was an exceptional case and said that the 2015-16 accounts supported the judge's conclusion that they were, because the accounts concluded the following passage. The account said that the company meets its day-to-day working capital requirements by having access to loans from its parent undertaking, that the company is dependent on continuing financial support being available from the bank, and the continued financial support should it be required from its parent undertaking. Furthermore, the parent undertaking had agreed to provide sufficient funds to the company should they be required to enable it to meet its liabilities as they fall due, and confirmed in each of their accounts support for a minimum of 12 months from the date of the approval of the financial statements. So the court said that in those circumstances, as with Tata Steel Limited, to ignore the holding company's resources would have been wrong and would have produced a misleading and unrealistic picture of Faltech's resources. The court agreed with the judge that he was entitled to have some limited regard to the holding company's resources in carrying out a proportionality assessment. The next case is that of NPS London. NPS London was a joint venture company, 80% of which was owned by a parent, which was ultimately owned by Norfolk County Council, and 20% of which was owned by the London Borough of Waltham Forest. The sentencing judge had treated NPS London as a large organisation for the purposes of Section 2 of the sentencing guidelines because it regarded the NPS parent as a linked organisation whose resources could properly be taken into account for the purposes of sentencing. The appeal court said that we think it's clear that the judge was wrong to read the guideline as entitling him to treat NPS London, or as it were, a large organisation for the purpose of sentencing. It is the offending organisation's turnover, not that of any linked organisation, which at step 2 of the guideline is to be used to identify the relevant table. Now that reflects the basic principle of company law, that a corporation is to be treated as a separate legal person with separate assets from its shareholders. An example of a case where it would be appropriate to treat the relevant figure for turnover as that of the parent company at step 2 might be one where a subsidiary had been used to carry out work with the deliberate intention of avoiding or reducing liability for non-compliance with its health and safety obligations. The mere fact, however, that the offender is a wholly owned subsidiary of a larger corporation, or that a parent company or other linked organisation is, in practice, likely to make funds available to enable the offending company to pay a fine, is not a reason to depart from established principles of company law or to treat the turnover of the linked organisation as if it were the offending organisation's turnover at step 2. The court continued that whether the resources of a linked organisation are available to the offender is a factor which may more readily be taken into account at step 3 when examining the financial circumstances in the round and assessing the economic realities of the organisation. It may certainly be relevant at stage 3 when checking whether the proposed fine is proportionate to the overall means of the offender, to take into account the economic reality. If it is demonstrated to the court's satisfaction that that is the reality, that the offender will not be dependent on its own financial resources to pay the fine, but can rely on a linked organisation to provide the funds. The final case we're going to look at is Bupa Care Homes. Now, Bupa Care Homes B&H Limited is a UK business which had as its undertaking Bupa Care Homes in the UK, and I'm going to call that Bupa Care. And Bupa Care has an ultimate global parent company called Bupa Limited. Now, an appeal was taken against sentence because the court had taken into account the turnover of the overall parenting company when sentencing Bupa Care. The court said that the starting point, as the court had observed in NPS London, is that the guideline has to be applied in a way which does not infringe ordinarily and well understood principles of company law. So the mere fact that one company may be a wholly owned subsidiary of a larger parent does not mean that the resources of the parent can be treated as available to or as part of the turnover of a subsidiary company, because they're not. The guideline phrase, economic realities, cannot be extended to mean that a parent's resources belong to the subsidiary simply in order to justify a large increase in a fine at step 3, any more than they can be taken into account to increase the size of the subsidiary's turnover for the purposes of the table in step 2. And the court continued, in other words, if it is generally wrong to take into account the parent's turnover so as to increase the subsidiary's turnover at step 2, which it is, then it is wrong to take it into account to increase the fine at step 3, absent some special factor of the type identified in Tata Steel or in NPS London. And the court went on to say that the defendant in this case, Bupa Care, was essentially arose out of their breaches of duty. Those duties had not been delegated to its parent company. Bupa Care alone bore criminal responsibility. It, on its own, was a large profitable organisation, and there was no suggestion that it would be unable to pay a fine or require its parent to pay it, or that it would not be a going concern without the financial support of its parent, and that in Bupa Care, those were the economic realities. And the fact that, as it was pointed out, Bupa Care remitted its profits to its parent was nothing on the point. Whilst fining Bupa Care would no doubt have served to decrease the amount remitted by it to its parent, that again did not alter the economic reality in that case. Now, I'm just going to hand back to Susan, who's going to sum all that up and conclude. Thanks, Susan.
Thank you, Adam. Yeah, as I said at the beginning, and I said I would come back to this, one of the first questions a client, when they know that they've got no defence to a prosecution, will ask you is, how much is this going to cost? And you can see from the English decisions that Adam has just looked at, that if the court can look at the wider financial picture of linked organisations, the financial penalty could be substantially higher than if the court were just dealing with the single accused company. So it's crucially important that you understand the structure of the linked companies and that you are informed by the client if there is financial support from another company in the group, because only then can you assess the economic reality of what you are dealing with. For all clients, ultimately, this comes down to numbers, and it is best to alert them to the worst case scenario at the earliest opportunity. And just a final word, there's salt to be rubbed into the client's financial wounds in the shape of the victim surcharge. Since the 25th of November of 2019, if the court imposes a financial penalty, it should impose a victim surcharge. There is a range dependent on the fine imposed, but if the fine is greater than £10,000, the surcharge is 7.5% of the fine. And to put that in a context, on a fine of £1 million, that is an additional penalty of 75,000. As a junior doctor once put it, this is going to hurt. It's best to give the clients the realistic advice at the earliest opportunity. Thank you very much for listening. If anyone has any questions, please just fire away.
Thank you. Thanks very much, Susan and Adam. That was excellent and extremely informative talk. I am conscious of the time this afternoon. So in terms of questioning, we've got one question from Graham Edward, which I think would be to Kay. And what he's asking is that, do you consider in all cases where a Section 17D defence is advanced, the court will fix a preliminary proof? Or do you think that there are cases where submissions or presumably a debate will be sufficient?
Well, I think it might depend on whether it's Section 17D2 or 3. The decision from the Sheriff Appeal Court was under Section 17D2, and as we know that they fixed a preliminary proof, and Bruce was saying that his experiences in the Court of Session, that seems to be being followed at the moment. In Section 17D3, the case that I was in, it was dealt with at a debate, and the court didn't need to hear any evidence in order to make a decision. So I'm afraid it's like many answers in the law, it depends. So yeah, it does depend. I mean, it really will depend on the particular circumstances. Whether you need evidence or you don't, and the way in which you deal with evidence. I should say that Bruce has had to head off for a consultation. That's why he's not here.
Good. Thank you. Thank you.
I'm sorry, Graham. That's probably not really answering the question.
Well, it's
best I can do.
There's still a lot of exploration to be done in the courts, which is always interesting for us, I suppose. So, but can I just thank all of the speakers enormously. It does take considerable time and effort to put these together. So thank you. They've been extremely informative and interesting. Can I also thank our clerking staff and Gavin Heard for organising the webinar, which hopefully you've all found interactive and helpful. And I'm sorry to have taken up your lunch hour that could have been helped with, could have been spent shopping, but we do very much appreciate you joining us this afternoon. So thank you again, and hopefully the next time we can all see you in person. So thank you very much.